I'll go straight ahead to talk about the types of arbitral awards. There are two main types, which are the domestic arbitral awards and the international arbitral awards. So basically, the domestic awards are those awards which emanate from arbitrations that were conducted within the territorial jurisdiction of Ghana, including customary arbitration. And then, second, we have international arbitrations. And this is defined particularly under Article 1.3 of the United Nations Commission on International Trade Law. So according to the definition, an arbitration is international, for instance, if the parties to the agreement, at the time they concluded the agreement, had their places of business in different states, or where the place of arbitration is different from the place where the parties concluded the agreement, or where the performance of a substantial part of the arbitration of the contract is different from the place of the subject matter of the dispute. And then lastly, where the parties have expressly agreed that the subject matter of the arbitration agreement relates to more than one country. I'll go straight ahead to talk about the enforcement regime surrounding the domestic arbitral awards. So basically in Ghana, it's the High Court that has been given supervisory powers over the arbitral procedure. And under Section 57 of the ADR Act, a party who wants to enforce an arbitral award has to apply to the High Court for leave to enforce the award in the same manner as a judgment of the court. However, leave may be refused, and under Section 57.3, leave may be refused to enforce the award if a party is able to show that the arbitrator lacked substantive jurisdiction to make the award. So this raises the question of what amounts to substantive or lack of substantive jurisdiction. This has not been expressly defined in the ADR Act, but a comparative study of the English Arbitration Act 1996, Section 30(1)(a), describes substantive jurisdiction as where there is a valid arbitration agreement, where the tribunal is properly constituted, and what matters have been submitted to arbitration in accordance with the arbitration agreement. And so the importance of a valid arbitration agreement is very essential to the reference to arbitration. So where there are defective arbitration clauses, sometimes you see in arbitration agreement, parties will choose arbitration and then also choose litigation in the High Court. That is an invalid arbitration agreement, incapable of referring the dispute to arbitration. And so these three, that is whether there's a valid arbitration agreement, whether the tribunal is properly constituted, and then what matters have been submitted to arbitration. These three are what constitutes substantive jurisdiction. And so when they are not present, then you say that the arbitrator lacked the substantive jurisdiction to adjudicate over the dispute. And it is under this ground that a party can apply to set aside the award under Section 57(3) of the ADR Act. Apart from Section 57(3), which is challenging the award on the basis of substantive jurisdiction, a party also has the right to set aside the award under Section 58(2) and 3 of the ADR Act on the one hand, and then Sections 28(1) and 1(e) of the ADR Act. So these are ways a party can challenge the award other than for lack of substantive jurisdiction. So when we come to Section 58(2), there are a number of requirements, a number of criteria that has been set for a party to meet if the party wants to certify the arbitral award. So 52(a), where a party to the arbitration was under some disability or incapacity. And an example is given in the case of Peterson Farms versus C&N Limited, 2004 BCWAC, where it was held that a person who was not an original party to the original contract, an award cannot be enforced against that party because that party lacked the requisite capacity. The other grounds include where the law applicable to the arbitration agreement is not valid, where the applicant was not given notice of the appointment of the arbitrator or of the proceedings, or was unable to present the applicant's case. And then when the award deals with a dispute not within the scope of the arbitration agreement or outside the agreement, except that the court shall not set aside any part of the award that falls within the agreement. E, where there has been failure to conform to the agreed procedure by the parties. And F, where the arbitrator has an interest in the subject matter of the arbitration, which the arbitrator failed to disclose. So in the case of Ade and Anani, 1973 to Ghana Law Reports 144 to 152, it was found that the arbitrator adjudicated the matter was related to one of the parties to the dispute. So the court was of the opinion that an arbitrator's position should not offend one of the rules of natural justice. And in this particular case, because of the likelihood of any legal bias, any decision that the arbitrator gave would be deemed as arbitrary and unenforceable. So aside Section 58.2, as I earlier mentioned, there is also Section 28.1e, which gives a party the right to set aside an arbitral award. So generally, Section 28 talks about the right of a party who is not notified of the arbitral proceedings. So there are distinct grounds under that section where a party who is not notified can apply to question the arbitral process. But Section 21E in particular gives a party not notified of the proceedings to apply to set aside on the ground of serious irregularity that affects the party. And once again, serious irregularity has not really been defined technically in the ADR Act. But if you look at the English Arbitration Act, Section 68.2, it defines serious irregularity as follows. Failure by the tribunal to comply with Section 33 in the English Arbitration Act, which is the general duty of the tribunal. And then where the tribunal exceeds its powers. Failure by the tribunal to conduct the proceedings in accordance with the procedure agreed to by the parties. Failure by the tribunal to deal with all the issues that were put to it. Any arbitral or other institution or person vested by the parties with powers to the proceedings or the award exceeding its powers. Uncertainty or ambiguity as to the effect of the award. The award being obtained by fraud, or the way in which it was procured being contrary to public policy. Failure to comply with the requirements as to the form of the award, or any irregularity in the conduct of the proceedings or in the award, which is admitted by the tribunal, or any arbitral or other institution or person vested by the parties with powers in relation to the proceedings or the award. So the question that this naturally raises is whether serious irregularity is enough to set aside an arbitral award. And this is answered in the English authority of ASM Shipping Limited and TTM Limited, where the court held that the right to challenge for serious irregularities is only available in cases where the tribunal had gone so wrong in the conduct of the arbitration that justice itself arises out for it to be corrected. And so when there is a presence of serious irregularity in the conduct of the arbitration proceedings, but there is no serious miscarriage of justice to any of the parties to the arbitration, then regardless, the arbitral award will be enforced. And this was the case in the Ghanaian case of Maritime and Dock Workers Union of the Trades Union Congress of Ghana versus the State Shipping Corporation, 1983, I believe this should be 84 Ghana Law Report 671 to 687. And in this particular case, the parties sought to set aside the arbitral award on the basis that the arbitrator had exceeded his jurisdiction. So, in the particular facts of this case, it involved an industrial dispute between employees of Black Star Line and then the management of Black Star Line. And the minister at the time appointed a sole arbitrator, and the reference to the arbitration was whether or not the employees should be given 20% allowance. But in addition to determining the reference, that particular question that was submitted to arbitration, the arbitrator went ahead to decide certain matters that was not necessarily submitted to him. So he found that the workers should not only be allowed 20% allowance, but the workers who were occupying company houses should be allowed to own them, and made an order that, or made a finding that the company should transfer title to the employees. So Black Star Line sought to set aside the award on grounds of serious irregularity, in that the arbitrator had exceeded his jurisdiction. But the court found that at the time that the matter was submitted, or the issue was raised in the arbitration proceedings, Black Star Line was present and did not object, or did not consent to the issues that were raised at the time the arbitrator sought to investigate it. And so the court held that the award was valid. So if you look at the holding, it says where an arbitrator has, by agreement of the parties, jurisdiction to determine disputes which may arise as to certain matters specified in the agreement, and the parties submit to him for identification matters not within his jurisdiction, both the arbitrator and the parties being under the misapprehension that the matters so submitted are within his jurisdiction, the award of the arbitrator is good. And so in this particular case, as I said, the reference to arbitration did not include whether or not the employees should be given the company houses, but there has been a serious miscarriage of justice, and the position was once again affirmed in the case of Checkpoint and Strathclyde. It's an English authority, and per Ward LJ, if I may read, he says the court should try to assess how the applicant would have conducted his case but for the procedural irregularity. And he continued that it is the denial of the fair hearing to summarize procedural irregularity which must be shown to have caused a substantial injustice. A technical irregularity may not, and the failure to deal with a substantial issue probably will. So in essence, what this case is trying to say that if, regardless of the serious irregularity, the party would have conducted his case in a similar way, then the award will be upheld, because it would deem that no serious miscarriage of justice had occasion to the party. So look also at waiver of rights to set aside an arbitral award, that is raising timeless objections. As I said, where a party is not notified of the arbitral proceedings, well, that party cannot be deemed generally to have waived his right to set aside an award. But where a party is notified of the arbitral proceedings and he participates in the proceedings, especially where he is aware of any irregularities and does not object to any of them, then Section 27 of the Act precludes the person from seeking to set aside the arbitral award, be deemed to have waived his right to set it aside. And so Section 27 particularizes what amounts to waiver as follows. Where a party who takes part or continues to take part in an arbitral proceeding, knowing that the arbitrator does not have jurisdiction or the proceedings are improperly conducted, or C, the arbitration agreement or this act has not been complied with, or there is an irregularity in respect of the arbitral proceedings, and who fails to promptly or within the time specified in the arbitration agreement or under this act to object to the proceedings, shall be deemed to have waived the right to raise the objection. And so, if you look at the act, if the arbitrator lacks substantive jurisdiction, which is what I explained when I began my the presentation at the introduction stages, where a party to the arbitration is of the opinion that the arbitrator lacks substantive jurisdiction, the act mandates the person to raise the objection immediately before he takes any further step in the proceedings. And then where a party is also of the opinion that the arbitrator is exceeding his jurisdiction, the party has to raise that objection timeously, immediately after the grounds for the objection arises. So if the party fails to raise these objections and goes ahead to participate in the conduct of the arbitration, and at the end of the day an award is made, the party will be deemed to have waived its right to set aside the arbitral award. I'd like at this point to refer us to the case of Hamlin and Bentley, which is also an English authority. The import of this case is that a party may raise an objection but still participate in the arbitration proceedings. So where that party raises the objection, he is not precluded from participating. And so far as he has raised the objection, at the end of the day, if an award is made, he will have the right to set it aside. So reading in particular what the judgment says, it says in arbitrations, where a protest is made against jurisdiction, the party protesting is not bound to retire. He may go through the whole case subject to the protest he has made. So the import of the decision is that where the party does not air his protest, when an arbitrator lacks or exceeds his jurisdiction or commits an irregularity, but continues to participate in the proceedings, the party will be held to have consented to the award emanating therefrom and cannot seek to challenge it later. However, where a party aired his objection at the time when the grounds for the objection arose, then he may continue to participate in the proceedings subject to his objection, and then later he may apply to set aside the award on the basis of his objection. So, another component of domestic arbitral awards is customary arbitration awards. Generally, the courts are slow to set aside customary arbitral awards, but Section 112 has prescribed certain grounds upon which a party may apply to set aside the arbitral award. These include where the award was made in breach of the rules of natural justice, where the award constitutes a miscarriage of justice, or the award is in contradiction with the known customs of the area concerned. And from the cases of Mante and Butri, 8991 Ghana Law Reports, it's a Court of Appeal decision, as well as Ade and Asante. In these cases, you see that the courts are slow to set aside a customary award, and the court even refused to pronounce on the merits of any award pursuant to a customary arbitration, even when it was unsupported by the evidence or made a mistake, unless the award was made in the breach of the rules of natural justice. Okay, so now that we are done with the domestic enforcement of domestic arbitral awards, I'll move on to enforcement of arbitral awards, international arbitral awards. So when it comes to enforcement of international arbitral awards, the key requirement is reciprocity and recognition of the international award. So it is very important that the country that gave the award has a reciprocal arrangement with Ghana, or its decisions are recognized under a law in force in Ghana. So if you look at Section 59 of the ADR Act, there are three main types of arbitral awards, international arbitral awards, that may be enforced by the court. The first is an award that was given by a competent authority under the laws of the country in which the award was made. And the second is where a reciprocal arrangement exists between the Republic of Ghana and the country in which the award was made. And then lastly, where the award was made under an international convention or any other international convention on arbitration which has been ratified by Parliament. And after these three key preconditions are met, the court will then go ahead to inquire whether the party seeking to enforce the award has provided the original award, or has produced a copy of the award. And secondly, whether the party has produced the agreement pursuant to which the award was made. And then lastly, the court will inquire as to whether there was an appeal pending against the award in any court under the law applicable to the arbitration. So The case of Dutch African Company and West African Mills, suit number MISC 0015/2016. This was a case that was decided by Justice Osei. He goes ahead to explain in detail the requirements for enforcement of international arbitral awards, particularly when it comes to the recognition and the principle of reciprocity. So, what this case is saying is that where the award was made by a competent authority recognized under the laws of that country, the party seeking to set aside the award or seeking to enforce the award, must either produce a reciprocal arrangement between Ghana and the foreign country, or it must show that the award was made pursuant to the New York Convention or any other international convention of which Ghana is a party. So it is when these three key elements are satisfied that the court will go ahead to inquire as to whether the original award of the arbitration is in court or the arbitration agreement. So it's like these three are preconditions to the enforcement of the international award. There are certain countries which are already recognized on the basis of reciprocity, and it is listed. These countries are listed under the Arbitration Foreign Awards Instrument 1963 LI 261. So if the country is not listed in LI 261, then the next step is for the party seeking to enforce the award to either produce a reciprocal arrangement or to show that the foreign country is a party to the New York Convention or any other international convention in force. And as I said, the recognition of the foreign state in either LI 261, the New York Convention, or any other international convention is a precondition to enforcement of international arbitration awards. Usually the question that is raised regarding international awards, the enforcement of international awards, is at which stage will the courts consider the necessity for reciprocity? So the question is, should reciprocity be considered at the time of the arbitration or at the time when the award is being enforced? This is especially important when at the stage where the arbitration award was made, there was no reciprocal arrangement existing between the state and between the state that made the award and the state in which the award is sought to be enforced. So in the case of Strojeck Sport and Edward Nasser and Co., in this particular case, the arbitration award was made in Prague, Czechoslovakia in 1962. At the time the award was made, Czech was not a reciprocating state under the Arbitration Act 1961, but it subsequently became one in 1963. So the question that was for consideration for the court was whether the award was enforceable in Ghana. And the court was of the opinion that the award would be enforceable in Ghana if at the time of the application to enforce it, the state in which it was made has in fact become a reciprocating state. It is immaterial whether at the time the award was made, the state in which it was made was or was not able to enforce it. And so, to answer this question, the stage at which reciprocity will be considered should be at the time of enforcement. Because if you look at this case, at the time they sought to enforce the award in 1965, the act had already been passed, and so although at the time the award was made, Czech was not a party to the Arbitration Act, it was able to enforce the Arbitration Act. Then there are grounds upon which a foreign arbitral award may not be enforced. And these grounds are stipulated under Section 59(3) of the ADR Act. And it reads, where the award has been annulled in the country in which it was made, or B, the party against whom the award is invoked was not given sufficient notice to to enable the party present the party's case. C. Where a party lacking legal capacity was not properly represented. D. Where the award does not deal with the issues submitted to arbitration. Or E. The award contains a decision beyond the scope of the matter submitted for arbitration.